I do hear voices. I don't take medication, and they force you to take medication and join.
Did I miss a whole page? I did. There we go. 1, 3, 4, 5, 6, 7, 8, 10 cases. Good morning. Are you Brandon Bonton?
Yes, ma'am.
And this is cause numbers 26 DCCR 0277, 278, 279, 280, 281, 282, 283, 284, 184, and 0490. And Mr. Bonton was examined for competency to stand trial by Dr. Grimsley. I received that report. I'm going to take judicial notice of the court file in all of the cases. The report is dated April 14th of 2026. The finding in that report is that Mr. Bonton is currently not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
Not from the state, Your Honor.
At this time, then, I am going to find that Mr. Bonton is not competent to stand trial. Hang on, let me say what I need to first, and then I'll let you.
Illuminati, man. I got a government microphone chip in my left knee, my right hand. I've been to the hospital. I understand the courts, man. Judge West know me. I'm not lying about nothing. I testified and take a lot of tick tests. I'm innocent. I got the right to freedom of speech, man. I'm asking for probation 2-year cap. So I go home today because these people on the Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join S. Dunn Behavior Center. Coach Lewis know me. I was sitting here. I had an aggravated robbery job. I shot a 9mm 2 times, one doorway.
Mr. Bonton, you can go
shot that 45.
Go back with the bailiff. You can go with the bailiff.
Talk, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonton is not competent to stand trial. Make
sacrifice him, man.
That inpatient restoration treatment is warranted. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility.
No.
Good morning.
Good morning.
You are Donald Cogdill?
Yes, ma'am.
And this is 26 DCCR 0005. Mr. Cogdill was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions, and also pled true to prior convictions, making this offense a second-degree felony. The agreement was for a cap of 8 years in prison. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, and I want to commend Justin Riley on what a great report he wrote. He really did it.
Ms. Malfino?
I have, Judge.
Any additions or corrections?
None, Your Honor.
Judge, obviously I am aware that the criminal history is of concern to the court. As you know from the indictment, the underlying offense itself is a state jail felony, and the offer was made just predicated on the nature of that offense with these priors. I'll defer to whatever you think is appropriate if in fact you think 8 is enough. No, I'm intended.
So I want to make sure, what's the status with parole? You're on parole, correct?
Yes.
Have you had a hearing out at the jail?
Now we're in a totally different kind of hearing. Donald has already pled guilty, but sentencing is still wide open under that cap, and the big question hanging over everything is parole, because if you're already on parole, one new case can become a legal avalanche.
Have they come to the jail for a hearing? Have you talked to anyone with parole about this case?
Somebody called over there. I don't know who it was.
Okay.
There's something about parole, not parole, but like, I don't know. I don't understand what he was saying.
Okay. There's a hold on him, correct? Sure. Mr. Parker, you may proceed.
I've had this same issue trying to figure some of this stuff out, Judge. I've talked to him, and the facts of this case, I mean, to my understanding, what the probation calls it, he was living in a transitional house, and I've talked to him about where he's going to live. He intends to go back to the transitional house, and he was working there in the kitchen. And the facts are that he was out, it started pouring down rain. He went to a house, he was on a back porch that he thought was vacant, and he was on the porch getting out of the rain, and 5 cop cars pulled up. And as he says in his report, I asked him, "Why did you run?" And he said, "Well, 5 cars pulled up, and I got scared." And I mean, and I've heard that a lot, but I mean, I think he's sincere in that. Not that it's justifiable, but that's what happened. He wasn't trying to break in the house, and that's what happened in this case. And I would point to the probation officer that thinks he might respond better to a structured guidance than to extended incarceration. It's in the top paragraph on page 5, the last sentence. And that's kind of my position.
The defense is painting the most sympathetic version possible. Rain fear confusion a transitional house, and someone who may need structure more than prison. It's a smart argument, but in court sympathy has to survive the record, and this record is about to matter a lot.
I think the last time he was in trouble, well, he's obviously been incarcerated, but it was in 2017. I clearly think that the probation office has pointed out everything that's about him thoroughly in this report, and just going back to his childhood, how he's raised and how he's lived, and his educational standing and his mental capacity. I think he's competent, but it's not as high as a lot of people that are out there, and he struggles to get by. But if it's possible, I think we would request he be allowed to be placed on probation. Understand the question about parole. Otherwise, we ask for on the lower end.
Small fee, no?
Judge, I really don't have much additional. I don't think he's a suitable probation candidate, although inference can be made from the offense itself that could have very easily turned into a burglary. I'm just glad we're not here on an offense involving him actually being inside someone's home or involving a child. So, but based on the mitigating factors pointed out by Mr. Riley, I'd ask the court to consider the 8.
So, Mr. Cogdill, I appreciate your attorney's argument. I understand. I can see that there's some issues cognitively. However, there's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times, and you're currently on parole.
Here comes the reveal that changes the temperature completely. 6 prior prison trips, multiple serious convictions, and he was already on parole at this point. The judge isn't just looking at this one chasesh, looking at a pattern, and patterns can destroy a probation request.
For 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then a indecency with a child. And it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing, and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff.
Follow me.